Hi, this is Josh Nelson with Nelson Elder Care Law, where we help you protect yourself and your loved ones from the curveballs of life. Today, we're going to be talking about a topic that always comes up whenever people move to Georgia, especially if we're coming to see our kids, or maybe we just want to come and enjoy the great property prices, the low taxes, and the beautiful weather. One of the things that we always want to consider whenever we move from state to state is how it affects our estate plan. A lot of people don't realize that estate plans are ruled by state law. So if I start out in a city like Orlando, Florida, and then move to Atlanta, Georgia, or if I start out over in Phoenix, Alabama, and I come over to Woodstock, Georgia, what do I need to do? There's three things that you need to check. Join us today on Live with a Lawyer every Wednesday at 3 p.m. in order to learn more tips and tricks. Today, we're going to be talking specifically about the three things you need to check for. One of the biggest things that people don't understand is that since it's ruled by state law, every state's a little bit different. If you're moving from a state that's what's called a community property state, which means you and your spouse own things 50-50, essentially no matter what, then whenever you go to a state like Georgia, which is not a community property state, it's really important to know, if I die, do things go to my wife? Unfortunately in Georgia, or fortunately if you're a child, they don't. It gets split between your spouse and your adult children if you have any. That's a big change for a lot of people and something that they don't normally anticipate. What that means often is if we don't have the right plan in place, your spouse will have to ask for your children to be able to return some things for them or do what's called a disclaimer. That can get awkward, especially if it's what we call a blended family. Maybe your children aren't with your current spouse. By having the right will or trust in place, we can avoid this problem, but we also want to make sure that it works right. So again, if you're moving from Alabama or Tennessee, Missouri, or especially Louisiana, you need to have your current estate plan reviewed very thoroughly. One of the things that we always want to look for in Georgia is how the house is titled. We also want to make sure that the things are executed properly, such as your will, power of attorney, advanced health care directives, HIPAA releases. How do we make sure that whenever somebody needs to come use your estate plan, it's going to work as you anticipate? Aside from making sure that if you're moving out of state into Georgia that you do have the whole thing reviewed, there's three primary things that we want to look for. First, is it signed and notarized properly? In the state of Georgia, we require a couple different things that other states do. Like on our power of attorney, we require at least 2 witnesses, but we also require a notary if you want that power of attorney to be effective to sell a house or real estate such as land. Some states don't require that, especially if you're moving from somewhere like Alabama, it's not required the same way. Or if you're moving from South Carolina, it probably doesn't work in Georgia the same way as easily as if you have it updated to the Georgia standard. If you're moving from a state like Florida, your power of attorney will often work in Georgia because in Florida they require 2 witnesses and a notary as well. But because in Florida you have a different homestead exemption that protects your house, whenever you go to Georgia, you have to make sure your plan incorporates those kind of protections. In Georgia, that threshold is extremely low, often for most families only $10,000 or $20,000 of protection, where in Florida, it could be your whole home. These are the nuances that we want to check for. So number 1 out of the 3 is making sure that everything's executed under the standards of your current state. Number 2 is going to be make sure that it's updated. If your estate plan is so old that the paper's turning brown, it's probably time for a review. It doesn't necessarily mean that things need to change. Things don't necessarily just expire. But there may have been rule changes, law changes, or you may have changed your mind. And by updating it, sometimes you can get things that are going to be easier on your spouse and your family, so it's not a burden to go through this process. We also don't want any kind of surprises, so tax laws especially change. Remember, as recently as 2009, if you have more than $600,000, you had to do some pretty crazy things in order to avoid estate tax. Currently, that number is extremely high. For a couple, it could be over $20 million. Most of us aren't going to realize those kind of estate taxes because we're not going to have $20 million whenever we pass. And so we don't need the complication of a plan that we might have needed in 2009. So if you have a really thick binder, a bunch of trusts that don't make sense to you, a lot of times it's helpful to go ahead and simplify that down. Make it so that your family doesn't have to go hire an attorney, especially a trust attorney, to administer a trust that wasn't necessarily needed for your current wealth in the current tax laws. Number 3 is making sure that you haven't changed your mind. A lot of times whenever people move to the state in their senior years is to be close to a child caregiver. It's because maybe your spouse has passed, you're moving closer to your oldest daughter, or maybe you have a son that has some medical experience that can really help look after you and help you make some decisions if you haven't lost the ability to make your own. And maybe it's not necessarily equal now that he's putting in more or she's putting in more time for you. Maybe you've loaned your kids some money and you want that to be offset. Again, just making sure that what it says is what you still want is number 3. And then there's a bonus one here. Whenever we start talking about the bonus, it's the fact that sometimes because these are ruled by state law, it is just plain easier to be able to use Georgia tools in the state of Georgia. If you float between a different state in Georgia, we can talk with you about what the best strategy for you is. But just because the banks in Georgia are used to seeing Georgia power of attorneys, and the hospitals and doctors are used to seeing Georgia advanced healthcare directives, sometimes whenever we use these tools in a crisis, it's just better to have something that they're familiar with. One of the great things about us at Nelson Novacare Law is we offer a free sit-down strategy session with a member of our legal team to help you go over these things, so you don't even have any skin in the game beyond your time. If you'd like to set up a second look of your estate plan, have us take a look at it, and just make some suggestions for you, maybe that suggestion is that you're great right now, you don't need any changes, but maybe it's something that we can catch before a crisis happens. Give us a call, 678-250-9355. Josh Nelson from Nelson Novacare Law. Thank you for joining us at Live with the Lawyer at 3 p.m. every Wednesday, and have a great day.